Hey everyone, welcome to First Fridays. I'll give it another minute as people start rolling in. Just as an introduction, my name is Katherine Del Rosario. I'm an associate attorney at McEntee Law Group, and we are based here in Chicago. First Fridays is our monthly appearance. It's not a show, but we come on here monthly with someone from our team to let you know recent immigration news and also take any questions that you might have about immigration. So, as I'm talking today, if anything comes to mind or you're wondering about something, please put it in the comments or send us a message, and I'm happy to answer what we can today. Just as a disclaimer, as always, I am an attorney, but I may not be your attorney. So this is meant to be general information. Every person's case truly is very different. So if you have specific questions, please contact us and we'd be happy to talk through what your options might be. All right, so I will get started. We have a couple of interesting news items to discuss. The first one is that USCIS, as of May, has updated their review process for parole applications for Cubans, Haitians, Nicaraguans, and Venezuelans. So currently, the US government is granting advanced travel authorization, so like a travel permit for up to 30,000 non citizens from the countries that I just named each month to come to the United States and seek parole. And they're doing this on a case by case basis. But there's been such a huge response to this that due to such high interest, they've updated the way that they're reviewing these cases. So under the new review process, USCIS will randomly select approximately half of the total applications in a given month, regardless of when they were filed, and review those. For the remaining half of the monthly applications, USCIS will review those on a first in, first out method. So for that pool of people, filing date will really matter. The other news item I wanted to touch on was Florida's new anti-immigration law. This is called Senate Bill 1718. And this strict new state legislation limits social services for undocumented immigrants. It sets aside millions of tax dollars to expand Florida's migrant relocation program or the busing program that we've mentioned before. It cancels driver's licenses that were issued to undocumented individuals by other states, so not Florida, and it requires hospitals that receive Medicaid funding to ask for a person's immigration status. Some of the other provisions that are those alone are very concerning, but some of the other ones that are especially problematic for the business community are there's going to be increased penalties for those who violate the state's new employment mandates. So under this new law, it will require private employers with 25 or more employees that are making new hires to use E-Verify. E-Verify is the federal online database that employers can use to confirm someone's ability to work. Now, this would have a significant impact on Florida in particular, and their agriculture, construction, and hospitality sectors that will definitely be impacted by this change. And so employers who fail to use E-Verify will be fined $1,000 per day. And for workers who are found to violate this new rule, it will be considered a felony to use a false ID in order to get a job. One of the other really concerning parts of this law is that there'll be a penalty for what's referred to as human smuggling, and that definition is not very clear even to immigration attorneys like myself. But under the new law, a person who transports into Florida someone they know or should have known is an immigrant who has not been inspected by authorities could be charged with a felony for human smuggling. That definition, again, for inspected is a little unclear. And under this law, theoretically, a US born spouse traveling from outside Florida into Florida with their husband or wife could be then charged with a third degree felony. So these are really, really just kind of outrageous and strict new laws that are now in effect. I don't want to end on such a poor note, but I wanted, to make you guys aware of some of these changes that are happening in our nation. But on to more like happy, positive news. We're in June now, and this is Immigrant Heritage Month. We are partnering with our community and our neighbors to collect gently used clothing. So if you are local to the Chicago area, we're collecting new gently used clothing inside the foyer of our building. We are located at 4245 North Knox Avenue. Although on the door you'll see 2112. That's the name of the music business incubator that we are a part of. And so you'll see a collection bin in the lobby, and we would really appreciate anything that you'd want to give. Donations are being accepted currently, and we'll be taking those until the 20th. These donations will be going to Nuevos Vecinos, it's an organization, a nonprofit here in Chicago that's helping recent migrant arrivals to Chicago get situated with their very basic needs, including clothing. All right. And we just wanted to have you mark your calendars for some upcoming presentations that are happening from our team. So Fiona, our managing partner, will be doing a presentation on O1A visas for sciences, education, business, and athletics on the 7th. It'll be an online webinar, so look out for that and definitely sign up. And then Natalia, my colleague, is doing a presentation on the K1 fiance visa. This will be on the 14th. We'll also be recording those if you're not able to join us live. Okay, just a reminder to send me any questions that you might have. You could put them straight into the comments. But we did receive some questions ahead of time, so I'm going to get into those now. So the first question is, what will happen if I get married to a green card holder, but I was already in the family filing process? Will it affect the process of getting a marriage-based green card, or will my process of family filing affect my marriage green card process? Okay, so as I understand, probably a parent or a sibling may have started the green card process for you, and during that time you've since gotten married, and want to know how these two things will affect each other. Now, it depends. It depends on who petitioned you in the first place. I assume you were in a preference category. So you may have been waiting in line or waiting for your visa to become current, and maybe that's why you don't have the green card yet. And if that's the case, basically, you can theoretically have two green card processes going, but ultimately USCIS will only approve one of them. And so you'll have to decide, which one you want to proceed with, but they're not going to negatively affect each other. Both will be on the record with USCIS, and when they're kind of in the final stages of approving one of them, they're going to ask you about it and say, which one do you want to proceed with? presently, if you are in the United States, a marriage-based green card based on marriage to a legal permanent resident, that will most likely be faster than the other case that you have going. I am pretty sure that for June, based on the June visa bulletin, that the visa is current in that category. So obviously, I'm not quite sure of what your specific circumstances are, and we can definitely talk to you about it. But in short, these won't negatively impact each other, but you kind of have to decide on one pathway. Okay, next question. I had my marriage-based green card interview in February and have not heard back yet. If my spouse is treating me badly, can I switch to VAWA? VAWA is the Violence Against Women Act. This is a green card option for battered spouses or children of green card holders or US citizens. And I would say this could be an option, but the timing is tricky because you may be very close to a decision on your green card case. Generally speaking, the way VAWA works is that if someone has been the victim of battery or extreme cruelty by their spouse or other relative, but in this case, a spouse, during the marriage, they can self-petition their own green card. And there is a process for that. And, we'd need some proof of the abuse. It doesn't mean that you needed to have reported the person to police necessarily, but some proof that the abuse has occurred and proof that the marriage was entered into in good faith, meaning at the time that you were married, did you intend to spend a life together? So what concerns me in this situation is that you may be very, very close to a decision anyway, but I would still contact an attorney, whether it's our office or another immigration attorney, to discuss it, because you're kind of in a critical period at this moment. Some people who are interested in VAWA, I've gotten this question a lot. What if I've already divorced the person, the US citizen or the green card holder, or what if I'm thinking about it? And the law allows, someone to pursue a VAWA self-petition within 2 years of a divorce. So if you are already divorced or considering it, and you've kind of thrown out the option because of that, don't just yet. Please talk to an attorney because you may still be within that window. Okay, next question is about conditional green cards and extension of status. So my conditional green card was extended for 24 months after previously being extended for 18. When is the best time to apply for citizenship? So this is a very common scenario. A conditional green card is, when you've been married for less than 2 years and you go through the green card process, the government will give you a temporary one valid for 2 years. It has conditions, it has strings attached, so you have to remove those conditions before the 2 years are up. It sounds like you've done that, and the government is taking such a long time processing this specific type of case. And so they are kind of proactively extending people's green cards, to help with the wait time. However, as long as you've met that obligation of applying to remove your conditions on time, you can still apply for citizenship within the allowed period, which, if you're still married to the US citizen, if that is how you got your green card, then you can file for citizenship 3 years after you got your initial green card. If you are no longer married to that person, then you can file 5 years after the issuance of your first green card. So there are some moving processes here and some moving timelines, but as long as you filed your petition to remove conditions on time, then it's 3 years. 3 years from the first green card, not the second one that you're still waiting on. You will also have to meet the other eligibility requirements for naturalization, such as physical presence and continuous residence requirements. You still have to meet the definition of someone with good moral character. And so you'll definitely still want to have a naturalization screening before you proceed. But yeah, we help folks with naturalization, conditional green cards all the time and are happy to help. Okay, I overstayed my visitor visa and a friend I had an issue with reported me. I now have someone I would like to marry in the US. Will this affect my application? It might not. I guess it depends on what that friend has said to the government. And it depends on your fiance's status. Now, if you are married to a US citizen and that person is sponsoring you for your green card, generally speaking, any periods of overstay of a visa or work without authorization are essentially a non-issue. You still have to meet other requirements, that you still have to answer questions about criminal issues, national security issues, and provide an accurate and complete history of where you've lived, where you've worked, and where you've traveled. Those things are all still the case. But this particular wrinkle in your case, I wouldn't say necessarily would that you wouldn't necessarily be able to overcome. But I would also recommend doing what's called a FOIA. So FOIA is a Freedom of Information Act request, and you can request a copy of your file from the Immigration Service or Customs and Border Patrol or the courts. And this can be helpful just to see what exactly your file contains. And we could potentially obtain a copy of whatever it is that your friend told the government, and I would do that. That's my recommendation. In general, it's a good idea to do a FOIA request. Other reasons you might want to do one is if you have criminal history. That doesn't mean you're not willing to disclose it, but maybe you don't remember, like it was a long time ago. You're not quite sure what the records, where they are and what they say, or if you're missing some of your identity documents, maybe they were with your parents or they were destroyed, a FOIA request can contain all of those things. So it's just very useful to have like your file, your records preserved and in your possession. Okay. Those were all the questions I got. I don't see any in the comments. Let me double check with my team. Okay. I don't see any other ones, but as always, we are here to answer your immigration questions, explore options for you. Follow us on our socials, set up a consultation with us, put our upcoming webinars in your calendar. And we're so happy to stay connected with our clients and just anyone who's interested in immigration. So again, my name's Katherine. Thanks for joining me today, and we'll see you next time. Bye-bye.